Our third case today is Zieler versus State of Florida, number 2023-1003. Good morning.
Good morning. May it please the court, I'm Steve Bulletin from the Bartow Public Defender's Office. With me at council table is Rachel Roebuck, a colleague who has also worked on the constitutional issues at the trial and appellate levels. This is an issue of first impression, and I don't think it's an exaggeration to say that it might be the issue of first impression in Florida capital sentencing since the Furman decision from the United States Supreme Court in 1972. While this court heard oral argument in the cases of Michael Jackson and Michael Hunt in December, Zieler's case was the first one briefed on this issue on the 8-4 statute, and it's the first one being argued on this issue on the 8-4 statute because the subject never came up by either the defense or the state or the court in the oral arguments in Jackson and Hunt. There's also the case where the issue regarding the lack of safeguards to comply with the principles of the Furman decision was comprehensively argued. Abbreviated forms of the argument were made in Jackson and Hunt. There's a first case where the absence of meaningful safeguards at the eligibility stage of a capital sentencing proceeding, the selection stage of a capital sentencing proceeding, and the appellate stage of a capital sentencing proceeding will be addressed at oral argument. Now, I need to quickly deal with one factor that was raised by the state in its brief in the Hunt case and was not addressed in the reply brief, which is that unlike in this case in the Hunt case, the state argued that the constitutional issue was not preserved because it was not raised below. It doesn't have to be raised below. The case law is clear from this court for decades that while a as-applied challenge to a constitutionality statute needs to be raised below, needs to be preserved, a facial constitutional challenge can be raised on for the first time on appeal, and that is what we have here. So I need to make that point. Now I want to start. There's three prongs here, and I analogize it to with the 8-4 statute in April of 2023. The legislature cut the third leg off a tripod. Okay, the proliferation of aggravating factors which do not genuinely narrow eligibility for a death sentence has been progressively gotten worse and worse with the addition of aggravators and the breadth of the aggravators over the years that it was worn down to a nub. Then in 2020, this court, and I respectfully say this court misinterpreted the U.S. Supreme Court's then 36-year-old case in Pulley versus Harris to dispense with proportionality review. That sawed off the second leg. Then by doing away with unanimity, and I want to say 3 years after the United States Supreme Court's Ramos case, by doing away with unanimity, they sawed off the third leg. It had been leaning against a wall, and now, I mean, it's just fallen. And the reason I say that the court misinterpreted the Pulley case in Lawrence is that Pulley did not say that proportionality review is categorically not required in a capital sentencing system. What it said was that California's 1977 statutory scheme did not violate the Constitution because there were sufficient other safeguards in California that in that state, proportionality was not absolutely required. Florida's system now is very, very different than California's. It was different than California's at the time of Justice Kennedy and Polston's dissent in Jacob in, I believe, 2014, and it's very different now. There was a period of 3 years when maybe it could be argued that Florida was more similar to California, where it didn't need proportionality, perhaps because it had unanimity. Now the problem is it didn't have genuine narrowing, but at least it had unanimity. Now it does not. Before Pulley was even decided, the Florida Supreme Court in a case called Booker in 1983 said that we don't need to worry about Pulley versus Harris because the Supreme Court has made it clear that it would not apply to states which are already doing proportionality review, which Florida was. Florida's proportionality review was cited with strong approval as one of the reasons why the statute was constitutional in the Profit versus Florida and in the Spaziano case, and even in Harris versus Alabama, where the court in 1995 said Alabama was okay because it's much like Florida, and they both do proportionality review. Shortly after Pulley came out, other courts, the Louisiana Supreme Court in a case called State v. Welcome made the point that this is like right after Pulley came out, that Pulley does not categorically say that proportionality review is never required. It depends on whether or not the presence or absence of other adequate safeguards in the system, in the statute. There's also a concurring opinion, I believe, by Justice Stewart in a Supreme Court case that said we take Pulley basically stands for the proposition that all states' systems are different, and we take a state's capital sentencing system as we find it. Now, Pulley expressly leaves open the possibility that a state system can lack sufficient safeguards that would not comply with Furman, but they say that California's system is not of that sort. The crux of my argument here today is that Florida's system is of that sort.
Counsel, can I interrupt you just for a second? If your client had been tried in 1990, am I correct that there would not have been a supermajority or unanimity requirement for the death recommendation?
That's absolutely correct, and that's the only reason why I'm not raising an ex post facto argument.
I guess my question is, aren't all of the arguments you're making about our current system equally applicable to the system we had in place in 1990? And if so, indeed, isn't this system an ameliorative improvement upon it in that there is a supermajority requirement now that wasn't in place in 1990?
Absolutely not. The system in 1990, while not perfect, arguably not even good, it was way better than the system today, because for one thing, we had proportionality, and this court took it very seriously. There were many, many cases that were reversed on proportionality, and one of the salutary or ameliorative things about that is over the course of time, it sent a message to trial judges and prosecutors as to what was a death case and what was not a death case. And as a result, gradually over time, you got fewer and fewer.
However, I find it, that argument works in principle as far as it goes, but I don't think we can consider it in a vacuum. I think the facts of this case, I think we would be hard-pressed to say in 1990 would make this not a death case.
That's why I'm not arguing constitutionality is applied. This is a Furman argument. When Furman was decided, it applied to every state statute that had the death penalty. Everybody on death row got relief on Furman. There was actually even a case that they didn't even get retried under new statutes. They were just resentenced to life. That included Charlie Manson. That included Sirhan. It included people that had, included cases, as you're saying, that you look at them and say, well, this is a death case. Now, the problem, what I have been arguing, I have argued this argument on the two prongs in cases that I thought were very, very mitigated. In the Michael Gordon case and the Tyrone Johnson case, I would have given you a different answer. I would have said if they were tried in a system that had proportionality, they would have been reversed for life. This case, I will tell you, I would not have argued proportionality even if it was available, but that's not the point. This is not an as-applied challenge. This is a facial challenge. What I'm saying here is that nobody can constitutionally be sentenced to death under Florida's death penalty system the way it currently is. I'm making an argument, and I hope I get to it today, on unanimity alone, that after Ramos in particular, that the 6th and the 8th Amendment and Article 1, Section 22 of the Florida Constitution independently require unanimity. But my argument here is that under the firm and safeguards argument, it requires something. And what has happened here is the safeguards have been obliterated at all three crucial stages of a capital sentencing proceeding. At the eligibility stage, you do not have the aggravating factors, do not genuinely narrow the class of people subject to a death sentence to a small subclass, because virtually everybody that is convicted of first-degree murder in Florida today starts off with at least one or more aggravating factors, and usually they're a typical death case, as you've seen, typically involves multiple aggravating factors, some of which may well be in dispute. Often hack is in dispute, CCP is in dispute, avoid lawful arrest is in dispute, but there's also aggravators that almost never can be disputed. Was the victim a child? Was the victim a law enforcement officer? Did the defendant have a 10-year-old strong-arm robbery or ag battery on his record? The main one that can hardly be disputed in the overwhelming majority of cases is that this happened in the course of a robbery or a burglary or an arson or a kidnapping or a sexual battery or an aggravated child abuse. I mean, if in a case where the defendant is separately charged with those things, he goes in there with an automatic aggravator, and under the state's theory, constitutionally, you could just tell the jury to go home because they found one aggravator in the guilt phase. Now, ordinarily, there's three ways you can convict somebody of first-degree murder. It can be felony murder only, felony murder and premeditated, or premeditated only. If it's generally thought that a felony murder only involves the lowest level of culpability of those three, and yet those people always are death eligible. Always are death eligible, because what happened there is you've got the felony murder statute, and it lists all of the usual suspects, underlying felonies, the ones that almost everybody charged with felony murder involves. But there, and it involves some rare ones too. It's got aircraft piracy and bomb throwing. But what happened is that there were in later years, there were some aggravators, some felonies added to the felony murder statute that were not added to the aggravating factor. So the state may come in there and say, well, hey, we can point to a couple of relatively rare felonies that don't get this aggravator. Well, wait a minute, look a little more closely. For example, escape is almost always going to have the escape aggravator, avoid lawful arrest, or hinder law enforcement. The one about the murder of a public official is going to have hinder law enforcement. Carjacking, and what was the other one? Carjacking, and there's a couple of them that were added that are always going to have the robbery and burglary aggravating factors. Resisting arrest with violence is almost always going to involve the death of a law enforcement officer. Can you conjure up a case where you're resisting a law enforcement officer and then somebody who's not a law enforcement officer gets killed in the course of that? Yeah, you can imagine that. But what is really hard to imagine, as Judge Eaton pointed out in front of the Legislative Committee, he said that it's almost impossible to imagine a first-degree murder case in Florida that would not start off with at least one aggravating circumstance. You can imagine one. It's not impossible, but it's hard, and they're few and far between. And that's not genuine narrowing if you cut like 100% to 99.1%. That's not genuine narrowing. Look at other states, some of the ones cited.
I'm sorry, you're arguing that there's a numerical threshold for what would be genuine narrowing?
I'm not arguing math. I don't like math. That's why I'm a lawyer. But I'm arguing just...
As I read Spaziano, I mean, what we need to be able to say is that that the scheme rationally distinguishes defendants. That it doesn't result in punishment that is arbitrary or freakish. Not that there is I mean, just to push on your fate, because you've articulated it as a facial challenge, I'm not sure you could sustain the argument that if the system sorted out but 1%, that it wouldn't meet the Spaziano test. I'm not sure that you win that argument.
Well, I mean, I think that, let me put it this way, going 100 different ways on this. First of all, Spaziano was heavily premised on the fact that Florida had proportionality review and takes it seriously. Spaziano was years before Ramos. The genuine narrowing thing, earlier on, I want to say maybe before Hearst versus Florida, there were two kinds of state capital sentencing systems. There was actually 30 kinds, but there were two main dichotomy there where you had what was called weighing states and non-weighing states, and that was a misnomer because all states had weighing. The difference was you had states like California, for example, where the eligibility and the eligibility determination and the selection determination were done separately. And then you had states like Florida where they basically ran together. And prior to Hearst, you didn't have a thing where death eligibility was based on the totality of the aggravators and not on the existence of one. And the proof of that is that for years and years under proportionality, this court said that in a single aggravator case, death is presumptively inappropriate unless there is very little or nothing in mitigation, and there were many reversals based on that. Now the script has been flipped, and if you have one aggravator, which again, I hesitate to use a number, but nearly everybody has, you're death eligible from the get-go. And all of the cases that talk about the genuine narrowing requirement, they do not talk about narrowing the selection. They talk about narrowing death eligibility. Now, we don't have that. Now, on the problem with the selection decision, we don't have genuine narrowing at the eligibility stage. We don't have unanimity at the selection stage. And the Ramos case came out in 2020, and I think that case is really important. Now, what the state says about that, well, the only thing they really can say is, well, Ramos applies to the guilt phase. It doesn't apply to the capital selection phase. Now, what they want to do, in effect, is say, okay, what the jury has to do is find unanimously beyond a reasonable doubt one aggravator. Okay, but a lot of the aggravators are indisputable, and a notary public could do it, right? Does he have a prior strong-arm robbery on his record? Was the victim a law enforcement officer? The jury finds that, and then they can go home. Okay, the cases that have rejected... They
don't just go home there, though, right? They also make an assessment of whether the aggravators outweigh the mitigators and make a recommendation to the judge,
right? But the state's argument is they don't have to.
Yeah. I just want to make sure that we don't mischaracterize what the system actually is.
No. In Florida, they do make a determination as to each aggravator, but that has nothing to do with eligibility. That has only to do with selection. And the problem with selection is, okay, the state, there are many cases that the court has seen where defense has made the argument, has been rejected by this court, other state courts, many federal circuit courts, that the weighing, the fact that the aggravators outweigh the mitigators, has to be made beyond a reasonable doubt. And I believe every court that has considered that has said no, that the weighing, the selection, is not a factual finding like, does he have an ag battery on his record? It is it's a moral judgment. Okay, I think that's fair. It's a moral judgment, but who should be making the moral judgment? Now I'm going to read a quotation written, an opinion of the Supreme Court, written by Justice Clarence Thomas in Jones v. United States in 1999. That's 527 U.S. 373 at 382. We have long been of the view that the very object of the jury system is to secure unanimity by a comparison of views and by arguments among the jurors themselves. We further have recognized that in a capital sentencing proceeding, the government has a strong interest in having the jury express the conscience of the community on the ultimate question of life or death. Okay, now this court in the Lloyd case a couple of years ago cites also Clarence Thomas's opinion in Glossop versus Gross, where he says essentially the same thing. Now, this is what a jury should be doing. This is should be making the decision by unanimous vote on the ultimate question of life or death. Now, I have the argument, the sixth argument in my brief is that the Sixth and Eighth Amendment in the Florida Constitution require that. But here my argument is just, it's not even necessarily that unanimity is absolutely required, it's just that unanimity is a very important safeguard, which the state has now seen fit to discard, just like it discarded proportionality and just like it's got aggravators that apply to everybody. Okay, now, in terms of, there are case after case talk about the importance of jury unanimity to reliability, to having every voice heard and people not, it's a safeguard against racial discrimination. The Oregon and Louisiana statutes. Okay, that's another thing about Spaziano, by the way, is that it doesn't have to do with unanimity. It doesn't cite Apodaca or Johnson. Oregon and Louisiana were the only two states that decided, hey, we're going to have non-unanimous jury verdicts. We're going to have 10-2 in Oregon, 9-3 later changed to 10-2 in Louisiana. And those cases were, in Apodaca and Johnson, the court said that's okay, but other states did not choose to follow suit. But the important thing there is that even and also that Justice Gorsuch's opinion in Ramos traces the history of the non-unanimity laws in Oregon and Louisiana. And in Louisiana, the legislative history, it was all racial discrimination. And in Oregon, it was the Ku Klux Klan. It was racial and religious discrimination. One was 1890s. I think Oregon was 1930s. Now, even those two states, even Louisiana and Oregon, exempted capital cases from the 10-2 and the 9-3. Even then, and when the Supreme Court was deciding Apodaca and Johnson, they knew that in a capital case, Louisiana and Oregon did require unanimous jury verdicts. This is, I believe, before you had the Furman bifurcation. I mean, I believe it was just like one trial in Louisiana and Oregon. They didn't separate out, well, you need it for the guilt, but you don't need it for the penalty. Now, lose my train of thought here. So the state's argument is and necessarily has to be. Ramos is bad for them on both the Fifth and the Sixth, the constitutional issues. What they have to say is, well, Ramos doesn't mean the capital sentencing decision. It only refers to the guilt phase. That stands the death is different principle on its head. Read the opinion of the Connecticut Supreme Court in a case called State versus Daniels that was cited with approval by this court in Steele that talks about the importance of jury unanimity to reliability of the selection decision. So we've got at the eligibility stage, we have got the safeguard has been removed. At the selection stage, the safeguard has now been removed. At the appellate stage, we have, based on what I would say is this court's misapprehension of what Pulley versus Harris stands for, we have no review over the appropriateness of a death sentence in a given case. We don't have proportionality review. We don't have within the case proportionality review after Cruz. And in the Hunt case, by the way, that's been misconstrued by the state. Does it mean also that you can't even do it as a mitigating factor with the jury or the trier of fact? That's a whole different thing for this court to say, we won't do it. But the court didn't say it's not a mitigating factor that the jury can consider. But in Profit, the Supreme Court said this court takes its review to separate out the few cases from where the death penalty is imposed from the many cases where it isn't, to limit the death penalty to a small subclass of offenders. Okay, in Profit, which was a case really early on, they said that the Supreme Court has reversed 8 out of 21 capital appeals it's heard. In Barclay, Justice Stevenson's concurring opinion in Barclay, which came quite a bit after Furman and Profit, said that out of 212 cases, the court had only affirmed 120, which means they reversed 92. Now, again, I'm not trying to do math, but what you had was a situation that the Wyoming Supreme Court has said, in a case called Olson, has said that a state Supreme Court's willingness to consider whether the death penalty is appropriate or inappropriate is an important determination to see whether this required safeguards are in place and effective. Now we've got a situation, I cited in a notice of additional authority just the other day, the most recent deferments in a case called Kaler. That brings it up now to 39 of the last 42. There have been 3 cases out of the last 42 in which a death sentence have been reversed, none of them because the death sentence was found to be inappropriate. 2 of them were waiver cases. One of them was the Cruz case where the judge considered something from another case that he shouldn't have considered. So they all went back, and they all have come back again. They're all, Cruz has already been affirmed a second time. Cruz has already been affirmed, and the other 2 are back. Even the one case that was reversed for a guilt phase issue, Avsonu, that one's back. So what we don't have is we don't have any appellate review of any kind, really, of whether or not the death penalty is appropriate. Not only do we not have proportionality review, not only do we have within the case proportionality review, this court has always been basically say we don't reweigh aggravating and mitigating circumstances. Enormous deference is given to the trial judge as to what aggravating circumstances are found and what mitigating circumstances are found or not found. The court also almost never messes with the weight that the trial judge gives to aggravating and mitigating circumstances. In the Tyrone Johnson case recently, I had argued that as to 2 mitigators, the trial judge actually conflated the law to use the 2 mitigators to cancel each other out. So he greatly diminished the weight that he gave to both Johnson's lack of a prior criminal history, which was undisputed, and his impaired capacity at the time of the crime, which was, again, based on the facts of that case, was pretty clear. And the judge basically used each mitigator to cancel out the other. I had an argument on that. The court didn't see fit to even remand for reconsideration.
I'm sorry to interrupt you. You're welcome to keep going, but you're down to 3 minutes.
I'll reserve the rest of my time for rebuttal. Anything I didn't get to argue, I'll stand on the briefs.
Thank you very much.
May it please the court, my name is Christina Pacheco and I represent the state of Florida in this case, and I have Jeffrey D'Souza, Acting Solicitor General, at the counsel's table with me. I think it's interesting that my friend Mr. Bulletin spent time emphasizing that he was not raising an as-applied constitutional challenge, instead that it's a facial challenge. And a facial challenge must be constitutional in all applications, and a facial challenge requires showing that the death penalty statute is unconstitutional in all applications. But as he concedes, his argument is based on 3 parts: the proportionality, the lack of a unanimous jury recommendation, and improper narrowing function. But he concedes that this case is proportional. He's not arguing that Zieler's death sentence was unproportional. While he spent a lot of time going over the aggravators and arguing that there were an improper narrowing function, in this case, certainly he cannot claim that narrowing did not occur when Zieler has the most weighty aggravators: CCP, HAP, a contemporaneous murder, and during the course of a burglary. And then he also conceded that this was a 1990 crime where Zieler would have been, had he not evaded justice for years, he would have been sentenced or under the previous statute just requiring a simple majority recommendation. he does not have an as-applied challenge, clearly, and he doesn't even have a facial constitutional challenge when the statute is not unconstitutional in this case. He spent a lot of time talking about the Eighth Amendment challenge, and does this court have any questions regarding anything that he discussed? I would just like to point out that this court has addressed these issues all individually and also combined. This court has long deemed that our aggravating factors are, they do have the sufficiently narrowing function, and that the statute is constitutional in that regard, and that that coupled with the lack or the elimination of proportionality review in Lawrence, that analysis was not changed and rendered unconstitutional once we took away the proportionality review. And then in terms of a unanimous jury recommendation, of course, this court recognized that that is not required in Poole, and that all that is required is a unanimous jury finding of an aggravating factor, but that a unanimous recommendation is not required. That is in line with the United States Supreme Court precedents in McKinney and Spaziano, and Ramos simply does not apply to Zieler's Sixth Amendment argument with that regard. Florida certainly has sufficient narrowing functions with regard to the eligibility, the aggravators that render someone eligible for the death penalty. Our two-part system, the jury is given plentiful mitigation that they are allowed to review pursuant to Lockett. The jury is never required to recommend a sentence of death. When they do recommend a sentence of death, that is reviewed by the trial court, and the trial court can override that. And when they recommend life, the court is obligated to impose that sentence. So there are certainly sufficient safeguards in place. There was no Eighth Amendment violation here, no Sixth Amendment violation, no error whatsoever. If this court has no further questions, the state respectfully requests that this court affirm Zieler's convictions and his constitutional and very well-deserved sentences of death.
Thank you.
The state, for obvious reasons, is trying to convert this from a facial constitutional challenge to an as-applied challenge. It's not. A facial challenge is unconstitutional as to all applications, and that's true here for the same reason that all of the pre-Furman statutes were unconstitutional in all applications. I intentionally did not raise an as-applied challenge, and nobody looked in Furman and said, okay, well, Furman probably deserves it, so we're not going to pay any attention to the problems with all these state statutes. The state also is trying to ignore the fact that our argument is holistic. It's a combination of the absence of any of these important safeguards. They are saying, well, it's already been decided against them, one thing at a time. They're ignoring changes in the law, such as Ramos, to the extent, I think in one of the briefs, they referred to our challenge as well-worn. This suit is well-worn. It's the only one I've owned for 20 years. This argument here is an issue of first impression. The statute is new. We've got Zieler, we've got Jackson, we've got Hunt. Each has somewhat different issues. I would argue that the safeguards issue and the unanimity issue are the most thoroughly argued in the Zieler case, and I'd urge the court to consider the arguments made in the briefs.
I'm sorry to interrupt you. What kind of objective standards would the court apply if we were just sort of looking, as you say, holistically at the, what the statute has in it and what, I guess, a deficiency in the statute that only became a problem when the court itself, receded on proportionality. I mean, how would we objectively try to even decide that?
Well, I'm not sure that you can objectively apply the current system either, but I would say to look at all three of these things, and ideally I would like the court to say that proportionality was an excellent way to separate out the true death cases from those that aren't, and we should bring it back, especially since Pulley and the conformity clause do not indicate otherwise. On unanimity, the court should require unanimity based on Ramos and based on the importance of unanimity to the moral judgment of whether a person should be sentenced to death or not.
But it sounds like your problem isn't so much if you isolate any individual. I mean, I know what you think about the proportionality jurisprudence, but it's not so much each thing standing alone. It's the way they all interact together.
Yes.
That you're saying that the system as a whole doesn't narrow sufficiently.
You got a bunch of lame analogies. I got the tripod, I got the trifecta, I got the interlocking building blocks. Yeah, I think you have to look at it holistically. And
so
also,
what's the target, though, is my point.
Excuse me?
If the target, you're saying that the overall problem is that it doesn't sufficiently narrow, but how would we even know what is sufficient?
Well, I think that's the problem at the eligibility stage. I think that like I said, there are equal reliability problems at the selection and the appeal stage, maybe even more so. I mean, can you just do a mathematical grid like the sentencing guidelines? I don't think that would be a good idea. I'd say go back to the way Florida did it from 2017, when the unanimity statute was reluctantly adopted pursuant to Hearst, until 2020 when Lawrence came out. But I just want to make the point also, when you say how can you objectively tell that Florida's system is not reliable or does not adequately protect against arbitrary and capricious infliction of death. Look at the statutes, look at the systems from the other 26 states that have the death penalty, and the federal government and the federal military. Every jurisdiction has either unanimity or proportionality. Many have both, but Florida is the only system that doesn't have either unanimity or proportionality. It
seems like both of those really, though, unanimity and proportionality are both, arguably, they introduce as much arbitrariness into this. Obviously, occasionally people are going to not be sentenced to death, but that doesn't mean that the system is more fair or more rational or more moral. If you have, one person vetoing it, or if you have judges kind of looking through, 1,000 precedents and trying to, see is this like this other case or whatever. I mean,
Justice Gorsuch in Ramos made the point that Louisiana and Oregon were on an island. The Birch versus Louisiana case talks about how the near uniform judgment of the nation is a very useful guide as to determining what practices are constitutional and what are not. Look at the other 26 states, look at the federal government, look at the federal military. Everybody has unanimity and proportionality except us. Many of the states have way more limited aggravating factors than Florida does. I mean, look at the two that I cited are two of the few where you don't have like the jury does not necessarily do the selection decision in Montana and Nebraska.
We could talk about this for hours. It's fascinating,
and it's
morally compelling. It sounds like it's a great issue for the legislature to think about.
It's in the brief, but I would just say look at how every other state does it. Even Alabama. You can have 30 seconds to finish. Okay, I'm going to make one last lame analogy. Florida system, we are the 2024 Chicago White Sox of capital sentencing. Chicago White Sox had the worst record anybody's had since 1899. Not 1999, 1899. They finished 20 games out of what would be 29th place out of 30 teams. We are the Chicago White Sox. Even Alabama has 10-2, not 8-4. And the reason we have 8-4 is because of an overreaction to Parkland.
Okay, I'm sorry. I respectfully, you need to wrap it up.
Sorry I went on, but I feel like it's important.
Thank you very much. We appreciate it. We'll be in recess for 10 minutes.
All rise.